competitive enterprise that must rightly engage their single-minded attention cannot expect it. We can't expect police officers without clear guidance to do anything other than try to protect us by whatever means are necessary. I mean, I wonder what my friend from California would said if this beating case we saw out in Los Angeles, if in the process of that beating, that person confessed to having murdered somebody. Should it be admissible? If in the process of that beating, I asked that question to my friend. What was the fellow's name? Rodney King. If when Rodney King was being beaten, the guy we saw on television, in the process of that beating, Rodney King confessed to a murder that he did commit, should Rodney King be convicted under our laws? That's my question.
I don't know under those circumstances. I really don't.
See, that's the problem.
The fact of the matter is, the answer is probably no.
Probably no.
Right.
Yeah. I
don't know how the courts would construe that, but probably no.
Well, usually the courts construe beatings, eliciting confessions, as not a good thing. And the reason they do that is we have a proposition about self-incrimination in our country. As a matter of fact, not only usually, always do they construe it that way. But my point is, there would be, assuming somebody had committed a murder, if the police beat the confession out of him, and he did commit the murder, and confessed to it, and that's what convicted him. Now, I wouldn't want that guy going free. I wouldn't want that person going free. They did commit a heinous murder. But the only way we're able to convict him is the police beat him up with a hose. Should that person be denied their constitutional rights? Well, my gut tells me no. Yes, they should be. Hang them. They did it. But why is it that we don't allow those kinds of things to be admissible? Why is that? Because it means that we're fearful if you allow that kind of practice, that practice gets used on innocent people as well. And we have a basic fundamental notion in our country that the means must justify the ends. Not that the end justifies the means. That's what this is all about. I promise you, given the police the authority to go out and protect us by whatever means is necessary, without any constitutional protection, we'd be safer from thugs. I promise you that. There'd be no question about that.
That point again,
but we've concluded, I will in a moment, we concluded in this society that we don't want that to happen. If we said tomorrow, the police can use whatever means they want to do away with the drug trade, I promise you, things would change. Things would change. They just go down everybody on a street corner without a trial, round them up. There'd be fewer drug dealers. And we'd be safer. But we made a judgment in this country. We don't do things like that. We have a constitution. Because in that net, innocent people will get caught who didn't do anything. And so, I guess the point I'm making here is what really is being done by my distinguished friend from South Carolina is he is stretching the means test. He is saying that as long as the result is something that helps, the means you use to arrive at that result is okay. As long as you found something that the guy did bad, it's okay. It's okay.
Yield on that, and I'll speak on my time.
On your time.
That's not what the senator is saying. He's saying in the case of your Rodney King illustration, if the police are beating him not knowing he murdered somebody, and in the process he blurts out, "I murdered somebody,"
How about if they knew he murdered somebody?
You what?
How about if they beat him knowing he murdered somebody?
Well, let's stick with your original one because it's more clear. No, well, either way, it'd be fine. But your original one is more clear. He's not saying that that should not be suppressed. What he's saying is, and I'd be the first to say, Yes, we let some absolute criminals go free because under our law, we're not going to allow illegal searches and seizures under the Fourth Amendment.
Right.
We let some people get off scot-free because they can take the Fifth Amendment against self-incrimination.
Right.
Some say that the reason Oliver North has had a reversal in his case is because of the limited use immunity that was granted and the tainted evidence that was used against him. He got off whether he did what was wrong or not. I uphold those rights, and so does the senator from South Carolina. All he's saying is that don't let him off when the police person has used objectively reasonable belief in obtaining the evidence that convicts that criminal. Don't let him off. In the case of Rodney King, that wouldn't be objectively reasonable belief that they're obtaining evidence that could be used to convict him. They'd be using brutal police force to do it. Now, I think there's a considerable difference between what the distinguished senator from South Carolina wants here and the President of the United States and the Attorney General of the United States and what you're characterizing it as. And I know you don't mean to mischaracterize it, so I'm not taking offense by it, but I'm just wanting to clarify this matter. He just wants reasonably obtained evidence with that standard to be allowed into evidence even though the policeman didn't have time to get a warrant. And frankly, that would be an improvement over current law where people are getting off on technicalities when the policeman acted with objectively reasonable belief that what he or she was doing was right. Now, that's all the distinguished senator from South Carolina is saying. And if we would move to that standard, yes, we would sweep more of these criminals off the street, and rightly so. Now, if we want to move to a police brutality standard, I'd be the first to stand side by side with the distinguished senator from Delaware and fight for the rights of those criminals, even though I know they're criminals, because that would be a violation of our basic fundamental rights under the Constitution. But I have to say, where you have a reasonable approach, and that's all he wants, why shouldn't that evidence be admitted? Why should it be suppressed? And why should these criminals, these murderers and drug kingpins and drug pushers and violent criminals be let off? Now that's what's involved here. It isn't as broad as the distinguished senator from Delaware is indicating.
Mr. President.
The chair might advise the senators that Senator Thurman asked that he be notified when 5 minutes is left on his time. There's now 5 minutes and 13 seconds. So, Senator from Delaware.
Mr. President, I yield myself 3 minutes and 30 seconds, and I'd be asked to be told when I've used that time, if I may. Mr. President, senators just confirmed the point I was making. The only point I was making by all these examples that I was using is that the senator made it sound like that he was against and I was for letting all these horrible, guilty people go free. And the senator has just acknowledged that he and the senator from South Carolina are willing to let horrible, guilty people go free when their constitutional rights are violated. And the fact that the change in the law that would occur under the Thurman proposal, you would still have thousands of horrible, guilty people go free. So the debate isn't, as the senator made it sound like the first 30 minutes of his talking, about whether or not the senator from Delaware is protecting those horrible, guilty criminals, and he wanted to get those horrible, guilty criminals that the senator from Delaware wanted to go free. That's not the debate. The debate is on that very small margin of people that would be captured by the change in the law. Is it worth trading off the basic constitutional rights in jeopardy that innocent people would be placed in, knowing that even if the senator from South Carolina's proposal becomes law, there are still horrible, guilty people who are going to go free because we have a Constitution and a basic principle that says the ends do not justify the means. the means must justify the ends. That's what we're all about. Now that we've established that, let's narrow it down very closely. The way the senator from Utah spoke earlier, he said that the Attorney General said, or his office said, that what I'm suggesting was really radically change Leon. I wish the Attorney General would get some new lawyers. Let me read from my proposal. The judicial officer in issuing the warrant was materially misled by information in an affidavit. That would be one example of detached and neutral. Let me read from the decision in Leon. Physical evidence seized by an officer reasonably relying on the warrant issued by a detached and neutral magistrate. Further on in Leon, because a search warrant provides a detached scrutiny of a neutral magistrate. Biden language, detached scrutiny, neutral magistrate, lacking any indicia of probable cause. Let me read from Leon. If the magistrate or judge in issuing the warrant is misled by information in an affidavit, and the affidavit knew was false or would have known, the affiant knew was false or should have known was false, except for his reckless disregard of the truth. Further on, also not applying the case where the issuing magistrate wholly abandoned his judicial role in the manner condemned in, and it names two cases. Go on. Again, in the Leon case, so lacking in indicia of probable cause to render official belief in the existence entirely unreasonable. Same language from our lacking the indicia of probable cause on page.
Time has expired.
You myself one more minute. The point is, we took the language from the Leon case. Now, if the Attorney General says all that is true about my legislation is true, it is also absolutely true of the existing case, the Leon case. You can still argue whether or not the magistrate was detached and neutral. That's the language in the Leon case. The Leon case says, and I quote it again from my friend on page 913 and 914 of the Leon case, and in mine on page 223. It says, if the search and seizure was carried out in a reasonable reliance on a warrant issued by a detached and neutral magistrate. Now, if it's arguable in my case that it's going to create, one more minute. If it's arguable in my case that it's going to create litigation, it clearly is already going to create litigation. It is in the Leon case, same language. I yield the floor. Reserve the balance of my time.
Mr. President, I yield 1 minute, taking Senator from Utah.
Without objection.
Mr. President, I am willing to let some criminals go free if, for example, their Fifth Amendment rights are violated or other amendment rights are violated. But I am not willing to let criminals go free when a police officer obtains evidence in an objectively reasonable belief that the search is legal. And the question is whether the Senator of Delaware is willing to let those criminals go free, because we certainly differ. Because unless he's willing to allow that language brought forth by the distinguished senator from South Carolina, the President of the United States, and the Justice Department to become law, those criminals are going to go free. The Constitution, incidentally, does not require the exclusionary rule. This is a judge-made rule. And I'd just like to make that point again. All we're asking is that that evidence not be suppressed, which is objectively and reasonably obtained. Thanks, Mr. President. I yield the floor.
Mr. President, I yield myself this time as may be required. Mr. President, the senator from Delaware refers to provisions which would permit law enforcement officers to knock down doors in bad faith and search our homes. Yet these provisions are not in my amendment. My amendment does not